state, Ms. Norgard.
Good morning. My name is Andrea Norgard, and I represent Mr. Hill. Why we are before this court is that Mr. Hill was sentenced as a prison release reoffender under a Florida statute that was systematically violating the Sixth Amendment to the United States Constitution by denying defendants who were facing PRR sentencing the right to a trial by jury, as well as findings that are beyond a reasonable doubt. Mr. Hill did not object to this procedure in the trial court at the time that he was sentenced in February of 2024. The law in Florida would have permitted the sentencing structure that he was sentenced under. However, in June of this year, the United States Supreme Court issued a decision in Erlinger versus the United States, which held that lien errors
This is during the pendency of his appeal, correct?
Correct, Your Honor. So Mr. Hill would qualify under Florida law as a pipeline case. His decision was not final at the time that Erlinger was issued, and Erlinger would apply directly then to him.
Does harmless error apply?
Your Honor, in this case, I do not believe that harmless error applies for three key reasons. Number one, the prison release reoffender statute violates constitutional rights, both the Sixth and the Fifth Amendment. And we have traditionally and historically in Florida not allowed a defendant to waive his right to a jury trial, but simply by acquiescence. Anytime that the right to a jury trial is waived, it requires a very specific waiver by the defendant. There needs to be a colloquy, he needs to be advised of the right that he is waiving, and there needs to be a determination.
From an appellate standpoint, is there any doubt that any reasonable jury would not accept the DOC's release date information?
Well, Your Honor, that depends upon what the court decides to require as far as that date. For example, in this particular instance, the state simply submitted what are sometimes called the crime and time or the PENPAC reports. However, there are other factors that can play into what a release date is. It can be the application of gain time. It can be whether there's been any type of post-conviction relief that has affected the sentence at all. And it would be our position that it's simply not allowable or permissible for the state to necessarily, during a jury trial proceeding, present only the PENPAC. The jury has the right to determine whether that release date is actually factually accurate. And I don't think that it's appropriate to assume that DOC never makes a mistake. And so I do believe that there would be additional proof required. It's not simply a ministerial act to determine what a released date is. Further, I do believe that Erlinger rejects arguments that this type of error can be harmless. That's disguising an argument for efficiency under the harmless error standard. Erlinger makes clear that it does not matter how straightforward it may appear to the judge or the parties that the requirements of the PRR statute have been met. That does not matter. The defendant still has the absolute right to have that jury make that determination, a right that goes back, as the Erlinger court outlined, to this country's founding principles. So no, I do not believe that the error in this case.
Isn't the state of the law that we do perform a harmless error analysis?
Harmless error analysis can be performed, but not when the error stems from what has been a structurally and systematically unconstitutional statute. Clearly, in State v. Manigo, the court held that.
Help me understand that last statement.
Are you trying to argue that it was not a procedural error for the judge to have made this determination rather than the jury?
I think that question, Judge Lucas, goes back to what is the error in the case. The error in the case is an illegal sentence. The sentencing order itself imposed an illegal sentence. That is an Alleyne error. It was not just the sentencing process. The process was tainted, but that tainted.
The error is that the finding was made by the trial court judge and not the jury.
But that resulted in an illegal sentence.
I understand that.
Well, so for example, in the seminal case in Florida that interprets the difference between the sentencing process and the sentencing order is Jackson. And in Jackson, the error that was raised was a Sixth Amendment claim for the right to counsel. Defense counsel, for whatever reason, had been absent during a time when some victim impact evidence had been presented. However, counsel's absence did not affect the legality of the actual sentence that was ultimately imposed. So the clear issue in Jackson and why the court in Jackson ruled that that was not a violation.
Here's what I'm trying out with the question, maybe you can address it.
Sure.
In Shiro versus Summerlin, the Supreme Court was construing this past ring decision, and it concluded that a sentencing judge sitting without a jury may not find an aggravated circumstance necessary for a position of death penalty. The Sixth Amendment requires a jury. This, it rested, they're saying the Ring case rested entirely on the Sixth Amendment's jury trial guarantee. Ring altered the range of permissible methods for determining whether defendant's conduct is punishable by death, requiring the jury rather than the judge finding the facts varying on the punishment. The court ultimately concluded that it was a procedural rule. Now that's in the context of imposing the death penalty. If that's the case, why isn't Randy Allen also similarly procedural, which means it could be waived, as it appears to have been the case when the judge asked about the PR designation. Defense counsel said, yes, it's there.
Well, I believe in this instance, though, there is a fundamental difference between acquiescence, which is what I believe that the defense attorney did in this case, because at the point in time that Mr. Hill was facing sentencing, had he requested a jury trial, the state would have objected and the court would have denied it. There was simply no ability in Florida at that point under Florida case law to have made that request and to have obtained that type of result. Acquiescence is different than actual waiver. Actual waiver requires that the individual, especially when you're talking about the waiver of a jury trial, would require that the defendant at minimum be informed of the right, that he has the right to the jury trial, and that there is some indication on the record that the waiver, not the acquiescence, but that the waiver was knowing, intelligent, and voluntarily made. Florida, the U.S. Constitution requires that when you are waiving a jury trial, when you enter a plea, when you are waiving your right to a jury trial, when you obtain a bench trial. We simply do not have that in the record. There is absolutely nothing in this record that could be construed or interpreted as a waiver as opposed to acquiescence.
What does your client want? Does he want a sentencing hearing? Does he want a jury trial? Or does he just want to strike into the PRR designation?
Our position would be that because the PRR statute is unconstitutional, that until the legislature, not the court, enacts a constitutional statute, that he should be entitled to resentencing under the Criminal Punishment Code. If that would be our best case scenario.
That's your home run.
That's my home run, you got it. However,
Basically, nobody can be sentenced PRR until this thing gets fixed.
exactly, and I don't believe that the statute can be fixed by simply changing the reasonable doubt, or adding reasonable doubt in and adding jury trial in. I mean, those are the structural components of the PRR statute. If you remove those, all you have left is how do you prove, what evidence proves the PRR, which would be the release date. When courts reconstruct statutes, when you remove every structural element of the statute, it's judicial legislation from the bench, and I don't believe that that would be appropriate in a manner that would salvage this statute. Secondly, though, however, if the court believes that it is possible to somehow resurrect what has been an unconstitutionally defective procedure from the beginning, then the alternative would be that at minimum Mr. Hill is entitled to go back to the trial court if he so wishes to require that a jury be impaneled and have his determination of whether or not he qualifies as PRR made by a jury. If not, at minimum, the record should contain a valid waiver of Mr. Hill of his constitutional right. I neglected to ask for my reservation of time. I don't know how much I
I was
have
gonna
left.
tell you, I'm saving 5 minutes for
Oh,
you.
thank you, Your
You're
Honor.
not at 15 yet.
Okay, and
You're
so.
at about 10.
Okay, so based upon that, Your Honor, that would be what we would be requesting. But at minimum, Mr. Hill is entitled to a resentencing. The state has conceded that PRR designations now must be found by a jury. The question this court has to determine is Mr. Hill entitled to it, and if at what point? Our position is that the 3800B2 motion was the appropriate vehicle to bring this to the court's attention. That Jackson does permit the correction of an illegal sentence, that this error, which, we characterize as an Alene error.
Well, but Jackson emphasized that the error should be in the order, the sentencing order.
Correct, Your Honor, and the error in this case is also in the order because it allowed the court, it mandated the court to impose the statutory maximum sentence, which the court did, of life and 15 years, and the operation in that order denies Mr. Hill the ability to achieve any type of gain time whatsoever. So there is an illegal sentence based upon the unconstitutionality of the PRR statute. How that error got there doesn't change the fact that it is an error in the order.
Well, so if it's an illegal sentence, why wouldn't 3800A work for you?
Because the error is present and the direct appeal is not over. I'm not suggesting that 38A could not work. It could certainly work to the benefit of someone whose sentence is final by the time Erlinger issued. But that is not the procedural position that Mr. Hill is in. He is a pipeline case. He is entitled to the benefits of Erlinger at this
Did we
juncture.
have to strike the initial brief in this case so he could file a motion, or had he not filed a brief yet?
You struck the brief upon my motion because at the time of the briefing, Erlinger had not, correct, Your Honor. And so the court, upon my motion to strike the brief, when it became apparent that now under Erlinger that an Anders brief could not
Was there
ethically
any
be filed.
objection to that?
Excuse me?
Was any objection filed to that? I looked, but I've forgotten what I saw.
There was no objection. We did consult with the Attorney General's office, and at that point in time, they were taking no position and would not raise an objection unless requested to by the court. Subsequently, and very shortly after that, the Attorney General's position changed, and we were asked to advise the courts, I think it was several weeks later, that they would object and they would file a response. However, by that point in time, the court had already entered the order striking the brief, correct, Your Honor, in this case. And that agreement was an agreement that was reached between both directors of the Appellate Division and the Attorney General's office and my office.
Okay.
And so again, when you come back to why should Mr. Hill be afforded?
And I just want to let you know you are now at 15.
Okay, thank you, Your Honor.
May it please the court, my name is Foster Swartz on behalf of the state of Florida. Barely 1 month after his release from prison, Ryan Hill committed a home invasion robbery and shot the homeowner from behind. At his sentencing, he conceded that the state could establish he had done so within 3 years of his release from prison. But now he would like to impanel a new jury, or better yet, avoid the PRR statute altogether. This court should deny him that opportunity because he failed to preserve the issue, which in any case is harmless. First, the rule that a Rule 3800B2 motion is an improper vehicle for preserving an Apprendi or an Elaine error claim flows directly from Jackson. Jackson sets forth a distinction between sentencing order errors, which are properly raised in and preserved by a 3800B2 motion, and sentencing procedure errors, which are not. As Judge Lucas said, Apprendi and Elaine errors are classic procedural errors. That's Schriero, that's also Hughes from the Florida Supreme Court. Because they are sentencing procedure errors, that is, errors that pertain to the process by which a defendant is sentenced.
But we have treated these as susceptible to 3800B motions, and I know that the brief referred to at least 2 cases as drive-by rulings. One of them, however, because I wrote it, cited Jackson, which you acknowledge is the seminal case on allowing a 3800B motion to be used under these circumstances.
Yes, Your Honor.
So, I think maybe I was wrong, maybe we were wrong in that decision, but we read Jackson to support allowing a 3,800.
Yes, Your Honor. The Hannum case from this court acknowledges that Jackson requires reconsideration of this court's prior precedents engaging with the scope of Rule 3800B2. In
I'm
Toy,
sorry, could you speak just a little louder?
oh yes, Your Honor, my apologies. In the Hannum case, this court acknowledged that Jackson requires reconsideration of its approach to Rule 3800B2. That engagement or that reconsideration didn't happen in Toy, and we don't see a ratio decidendi, a rationale for the decision articulated.
Well, the problem in Toy is an earlier panel, while that case was pending, either on motion or maybe sua sponte, I don't remember which. I don't know if you looked at the docket in that, but relinquished jurisdiction and redirected that Toy file, a 3800B. So there's that.
Yes, Your Honor, there is. We would note that similar motions have been denied as untimely in more recent cases, asking for Andrew's briefs to be stricken or for the jurisdiction to be relinquished.
Yeah, I noticed that the sub-district courts, once the brief is filed, they're not allowing people to strike the brief.
Yes, Your Honor.
Right, and go ahead and file a motion.
Yes, Your Honor.
I don't see anything in the rule that prohibits doing that, but I have seen what you're talking about.
Yes, Your Honor. And so we think that because of this, this court would not need to sit on banc in order to recede from that ruling in Toy that a Rule 3800B2 motion is a proper vehicle for preserving an Apprendi error claim. That said, the state would not oppose a
Well,
non-agree.
I want to talk a little bit, because I'm really interested in this issue, and I'm not, opposed to rethinking the propriety of 3800B under these circumstances. But, Jackson talks about the error in the order.
Yes, Your Honor.
And there definitely is an error in the order. So to me, this is a hybrid. I see the procedural aspect of it. So can you address that for me, please? The fact that it's really a hybrid. It's somewhere in between, I think.
Well, Your Honor, we think that every error that occurs during the sentencing process could manifest in the ultimate sentencing order entered somehow. And it's a question, I suppose, of how apparent it is on the face of the order that the error occurred. Jackson makes clear that Rule 3800B2 was never intended to allow a defendant to sit silent in the face of an obvious procedural error to which they could have objected. And we think this is the apotheosis of that sort of procedural error. We acknowledge that sentencing errors, as the Jackson court listed, include substantive errors, that is, claims that this enhancement could not have been applied to that type of offense, that's Brannon, or that because the entire sentencing statute was unconstitutional, the defendant could not have been sentenced under that statute at all. That's Salters. It also acknowledges errors which pertain to notice issues. For example, in Mapp, where the defendant received no prior notice that he qualified for an enhancement as a habitual violent felony offender, or even in this case, the first 3800B2 motion, where the argument made was that the judge's directions at the sentencing proceeding were unclear, and it wasn't until the sentencing order was entered that Mr. Hill actually knew what his sentences were, what his enhancements were.
Yeah, but Jackson also rejects the idea that you can't be aware, and that you only become aware of the error when the order is issued.
Yes, Your Honor, and that's why we think that it also includes errors with the substantive sentence imposed. So if your claim is, for my type of offense, I could never have received that sentence, that sentence exceeds the statutory maximum. For my type of offense, we think that's a good use of the 3800B2 motion. But whether it's phrased as substantive errors or properly raised or errors that could only have been ascertained after the order was entered, we know that in either case, what cannot be raised in the 3800B2 motion are classic procedural errors like this. Because again, this is something that Mr. Hill's counsel could have objected to, not only did not object to, but he conceded on page 730 of the transcript that the state could establish that his client was a prison releasee reoffender. Because of that, we think that this attempt to now reopen and impanel a second jury 7 months after the fact would be a waste of judicial resources. Now, I'll note that we don't think that on page 730 of the transcript that concession amounts to a waiver. We don't think it qualifies. It doesn't have the requisite attributes of a colloquy and a signed writing and all that. However, we do think, if anything, it certainly goes to harmlessness if this court was to find a preserved error, it was acknowledged even then by Mr. Hill's counsel that the evidence showed that Mr. Hill was a prison releasee reoffender. That is to say, 100% of the evidence in the record, and we have to look at the entire record on a harmless error review, shows that Mr. Hill was released on July 28th, 2022. That's the pen pack on page 153 of the appellate record. And as this conviction shows, reoffended on September 2nd, 2022. A jury would have to find that that pen pack was off by 2 years and 11 months in order for the sentences that obtained here to be any different. And so we think this is, even if there is a preserved issue here, which we don't think there is, it is certainly harmless, and this court can affirm on that ground alone. Now, even if this court were to find a preserved and harmful error, we think, as the Monaco court said, that the right remedy here is to impanel a new jury to find the fact in question. To the extent that Williams held that the right remedy in a situation like this is to just sentence the defendant under the more lenient criminal punishment code, Monaco expressly receded from that and receded from its concerns about double jeopardy being implicated. So under Monaco, the right remedy here would be to...
I'm sorry, could you repeat that?
Yes, Your Honor. Under Monaco, the right remedy here would be to impanel a new jury to find the fact in question. It would not be to merely sentence people under the more lenient criminal punishment code. I'd just like to note that to the extent that Mr. Hill wants to frame his claim as one that the entire sentencing statute is unconstitutional, that claim is not properly before the court. In order to make out that argument, he would have had to show either that any other part of this statute was unconstitutional than the phrase by a preponderance of the evidence, or he would have had to explain why that phrase was not severable from the rest of the statute. He's done neither. There are no severability arguments.
In that same vein, can you walk me through, how would a facial constitutional challenge be framed and raised and argued in a 3800B motion context? How would that even work?
Your Honor, I think it would be like the Salters case. So the issue in Salters was that, or the claim in Salters, was that the statute under which the defendant was sentenced violated the single subject rule under the Florida Constitution such that it was unconstitutional in its entirety. I think if you're not saying something like that, if you're not putting to an error which obviously infects the entirety of the statute, if you're just saying this part of the statute is unconstitutional and you still want to be totally free from it, as Mr. Hill does here, you'd have to go to the Schmidt, the four-part Schmidt test, and say it's not severable. You'd have to say it's not severable from the rest of the text. The legislature wouldn't have passed the rest of the statute without that. It changes.
Let me be clear. I understand analytically how you're framing it. I mean, procedurally, in terms of, because typically this is not a constitutional challenge that is typically raised. So walk me through how that would work in a 3800B2 context. Because I'm having a hard time imagining how a post-conviction court handles it in that kind of framework. Because I mean, typical constitutional challenge, the AG's office, and obviously the AG's office appeal out, the AG's office gets noticed. There's briefing that goes into it. There might even be a need for a limited evidentiary hearing, just depending upon whether there's a dispute about whether it applies in all contexts or not. So that's what I'm trying to understand.
Yes, sir. I confess I struggled to envision it myself, but I think what would happen is it would be raised in the Rule 3802 motion. The trial court would perform this evidentiary hearing if one is called for, would go through the analysis. One of the problems about a Rule 3802 motion...
potentially rule in a post-conviction 3800B2 correct a legal sentence that an entire Florida statute is facially unconstitutional. It's pretty strong medicine for...
Agreed, Your Honor.
Procedure.
I think that is the process contemplated by Salters as affirmed in Jackson, but if you'd like more information, I can get that to you at a later date. I'll note that one issue with using Rule 3800B2 motions this far after the fact to raise procedural errors or errors of this nature is that, as we know from Monaco, a trial court cannot sit in harmless error review of its own error. And so basically, the trial court would be forced to impanel a new jury if it finds an error, even if it's a case like this where it's obviously harmless, because the defendant reoffended within 1 month of his release from prison. So again, we think that this issue was unpreserved below. We think that even if it is preserved, it is certainly harmless. And if there are no further questions, we ask that you affirm. Thank you.
Judge Lucas, just to clarify, a 3800B2 motion is not a post-conviction motion. It is a motion that allows the trial court, during the pendency of a direct appeal, to correct a sentencing error. Alene itself acknowledges that not all sentencing errors are apparent at the time that the sentence occurs. Hence, when the United States Supreme Court holds that a statute that requires or permits a judge rather than a jury to make findings that increase a sentence and to allow that to be done by a preponderance of the evidence as opposed to beyond a reasonable doubt, that is an error that should and can be corrected on B2. The Florida Supreme Court has held that B2 can be used to correct challenges to the constitutionality of a statute. And in this particular instance, the U.S. Supreme Court's already made that determination that these type of statutes violate the Sixth Amendment and the Fifth Amendment.
Shaviro has held that this is a procedural kind of error that can potentially be waived or unpreserved depending upon.
Well, I think though that Erlinger also answers the harmless error question. Really, the harmless error argument that the state puts forth is a roundabout way of re-arguing what Erlinger already said is not permissible, and that's efficiency. To argue that why in the world can this not be harmless because the jury would clearly make the same finding is essentially arguing why in the world should we have to have juries do this, because it's very clear that they're going to decide the same thing anyway, that there's absolutely no question that that's what the documents show, that that's what the jury will find. And I believe that Erlinger said, no, that is not the standard that we use to evaluate these types of issues. It may be absolutely straightforward, but a defendant still has the right to have a jury of his peers make those determinations. Judge Kelly?
Yeah, but I mean, the Florida Supreme Court has said that Alene errors are subject to a harmless error analysis.
But I believe that,
Aren't we stuck with that?
but Erlinger makes it clear they're not. And I think where Erlinger makes it clear is when Erlinger says efficiency is not what we're using, burdensome on the judicial system is not what we're using to determine whether a defendant's constitutional rights have been violated or not.
But it's a very narrow issue we're looking at. The only question I understand your claim made was whether the 3-year is satisfied, right?
Under the statute, in order to obtain the PRR designation, the state must show that the release date from prison was within 3 years of the current offense.
And trial counsel conceded yes.
Trial counsel did not object. Trial counsel also did not have the benefit of Erlinger, which makes it very clear that even that type of fact-finding is not ministerial, that it comes within the purview of the jury. Erlinger makes it...
It's certainly not a situation where we're having arguments about gaining time and stuff like that, as you suggested earlier.
We don't know, because that was not an issue that was litigated in the trial court. So I can't represent to the court whether there are any issues related to that in this case or not. That was something that was never before the court, before the trial court. It's also abundantly clear that Erlinger specifically now prohibits judges from making any factual determination at a sentencing hearing beyond, number one, the fact there is a prior conviction and the elements of that offense. Anything else has to be made by the jury. And, in returning
Unless
to...
counsel concedes it or waives it because they don't want that information being heard by the jury, right?
Well,
Which
Erlinger-
is a strategic decision that makes a lot of sense.
Well, yes, but Erlinger sets out, and it's a common practice that's used in Florida for many things, for felon in possession charges, for felony battery, for felony DUI, that bifurcation is one option. And that's the option actually that Erlinger suggests. So that would not necessarily, those facts would not come before the jury at the time. You know, in a death penalty trial, we don't try the aggravators during the guilt phase, we try them in the penalty phase. So Erlinger itself proposed, and again, absolutely and unequivocally shot down every argument that was forwarded by amicus, since the government had conceded in Erlinger that the statute was unconstitutional and they could not use the ACA records. So the court appointed amicus counsel to argue that position. And, you know, and honestly, I feel very sorry for amicus counsel, and then proceeded to shoot down every argument they made, including those related to anything to do with judicial efficiency.
Thank you. You're at the conclusion of your time.
Thank you, Your Honor.
Thank you both.
I have no other cases. May I be excused?
Pardon me?
I have no other cases. May I be excused?